जम्मू आ गए, दिल्ली आ गए, अलग अलग जगह पे आ गए, और अभी सरकार उनको करेगी फिर से हम
मेरी बात समझ गए क्या? सबके साथ मर्डर हो जाता है क्या? सारी बहुएं जला के मार दी जाती हैं?
Under criminal law, the subjects are limited to BNS and the BNSS. Almost every other subject that we study falls under the civil category. So civil is much more broader than criminal, right? And 90% of the laws, they fall under the civil category, and to regulate those 90% of the laws, there is only one code, which is the CPC. So immediately you can see the importance of CPC, that CPC regulates 90% of the laws. So as the proposition goes, that if you want to understand law, you must be thorough with the CPC. So substantive law can be any of these, but the procedural law has to be CPC, right? Now, that was from an understanding point of view. If you are going for judicial service examinations, वहाँ पर याद रखना, the examination is held in stages, and at the prelim stage, you will get somewhere between 15 to 20 questions from CPC itself. Okay? This is considered as a major subject, and that is why you can easily expect 15 to 20 questions from CPC itself, right? Now, at the main stage, there is a bit difference, because there is a separate paper on procedural law, right? And in this, you get questions from the CPC and the BNS, the BNSS, the Bharatiya Nagarik Sureksha Samhita, and the Bharatiya Saksha Adhiniyam, right? So even at the main stage, you can see that 1/3 weightage is still given to the CPC. Not only that, in some mains examination, not all, but in some mains examination, you will have to write the plaint, you will have to write the written statement, and in some exams, there is also the questions for judgment writing. So you will only be able to write the plaint when you are thorough with CPC. You will only be able to write the WS when you are thorough with CPC, and same is the case with judgment writing. Okay? So even from an examination point of view, you can see that CPC becomes a very important subject for you to study, right? So either from an understanding point of view or an exam point of view, both CPC becomes a very important subject for you to study, right? Now, to understand the importance of CPC, that's the easy part. But to understand CPC, that can be a bit of a challenge, because if you don't know the proper way to study CPC, it can be really confusing. Okay? And to understand CPC, or the proper way of studying CPC, is to divide CPC into two parts. Okay? The first part is the sections, and the other part is the orders. So to understand CPC, divide CPC into sections and orders. Now, in the context of CPC, what do you mean by sections and what do you mean by orders? So sections give you the general principles or the broad framework. So what is the purpose of the sections? Sections only give you the principles or the framework, right? They do not go into details. There will be no details in the sections. Sections only give you the principles or the framework. If you want the details, you must go to the orders, because these are deemed as the real elaboration of proceedings, right? These are the provisions which will contain the details. Okay? So to understand CPC, पहला काम क्या करना है? We have to divide CPC into sections and orders. Sections give you the principles of the framework, but they do not go into the details. The details are always going to be in the orders, because these are deemed as a real elaboration of proceedings. So this is the first thing we have to do. Now, the second thing we have to remember is, for almost every important section, and this is a very important part, ध्यान सुनना, for almost every important section, there will be a corresponding order. For almost every important section, there will be a corresponding order. So the question was, what is the proper way to study CPC? The proper way to study CPC is, you study the section and then directly go to the corresponding order. Okay? That is the proper way to study CPC. Do not study CPC section wise and order wise. Section wise, do not study it, and order wise, do not study it. Okay? How do you study CPC? You study the section and then directly jump to the corresponding order. Okay? So there are many sections in CPC which have a corresponding order. So let's look at some examples where a section has a corresponding order, and because you are going through CPC right now, some students have informed me, so you can just check in the bare act and don't go through the entire bare act, just check the index. Okay? Chalo. Now suppose we are covering the topic of institution of suits, right? For this we need section 26 and the corresponding order is order 4. So after section 26 we don't go to section 27, we directly go to order 4. Okay? The section is going to give us the principles of the framework, the details are going to be in the orders, right? Now why did we not go to section 27? Because section 27 to 32 is a completely different topic. This is summons, right? And summons के लिए the corresponding order is order 5. Okay? So याद रखना that few examples, I will give you many more. Suppose कि let's say we are doing the topic of judgment and decree. For this we need section 33 and the corresponding order is going to be order 20, right? Agar let's say we are doing the topic of execution, so for execution we need sections 36 to 74 and the order is order 21. Agar let's say we are going through the topic of commissions, so for commissions we need section 75 and the order is order 26. Let's say we are going through the topic of temporary injunctions, so for temporary injunctions we need section 94C and the order is order 39. If we are going through the topic of receiver, so for receiver we need section 94D and the order is order 40. If we are going through the topic of, let's say, first appeals, so for first appeals we need sections 96 to 99 and the order is order 41. If we are going through the topic of second appeals, right, we need sections 100, 103 and the order is order 42. If we need to understand appealable orders, for appealable orders we need section 104 and the order is order 43. If we go through the topic of reference, for reference we need section 113 and the order is order 46. If we go through the topic of review, for review we need section 114 and the order is order 47. Okay? So just few examples jahan par ki we have a section which has a corresponding order. Okay? If you have the Bare Act, Janani and Chandramohan, Narendra, if you have the Bare Act, you can check in the index itself. So these are few examples where a section has a corresponding order. I can give you many more, like in interpreter suits, we have section 88 and then the corresponding order is order 35. Then we have out of court settlement, which is section 89, and then we have order 10 ka rule 1A, 1B and 1C. Okay? Many more examples. But the point is, whenever you study CPC, don't start section wise and order wise. That is not the proper way. The proper way is you study the section and then you go to the corresponding order. The section is going to give us the principles of the framework but not the details. Okay? Details ke liye you always need the orders, and that is why section ke baad, like let's see here, reference mein the section is section 113 and the next section is section 114, which is a completely different topic. That is why after section 113 you should go to the corresponding order, which is order 46. Aise hi review mein section 114 ke baad we directly go to order 47, right? So all our students, everyone, is this part clear that CPC should not be studied section wise and order wise? CPC should always be studied by section and then going to the corresponding order. Is this part clear, everyone? Okay, chalo. Right. But although this is a very good thing to do, but that does not mean you can pick up any random section and go to the corresponding order. Okay? Nahi, that is not the proper way. Although this is good, but this must not be done in a random way. And you need to ask the question, okay, how does an ordinary suit run? How does an ordinary suit run? This is a fundamental question which you should keep in mind while studying CPC. Okay? So, can anybody tell me how does a suit start? Anyone? Because CPC is ongoing, can anyone tell me how does a suit start? Anyone? Anyone? Chandramohan, Janani, Parakram, Narendra? Anyone else? Harika, Gokila, Geeta? Very good. It starts with the filing of the plaint. So first of all, what happens is, the plaintiff comes to the court and files his plaint. That's how a suit starts, right? Section 26(1) says, every suit shall be instituted by presenting a plaint or in such other manner as may be prescribed. Okay? So how does a suit start? The general rule is, a suit is started by the presentation of a plaint. Now, after the plaintiff has filed the plaint, what is the second step? Anyone? What is the second step after you have filed the suit? You have started the suit. Plaint file kar diya. What is the next step? Anyone? Janani, Indra, Geeta, Gokila, Bhumika, Arshia, Aditi, anyone beta? My question is not specific to Janani. What is the second step? Anyone? Prachi, if you are saying something, it's not audible. Okay, so the second step is the service of summons. Okay, so after the plaint has been filed and the has been instituted, now we need to inform the defendant that a suit has been filed against you. And how do you give that information? By serving a summons upon the defendant, first thing. Now, after the summons have been served, next, the defendant is going to file his reply, which is known as the written statement. Okay. So, first of all, the plaintiff is going to file his plaint, then the summons are going to be served, then the defendant files his reply to the allegations made in the plaint, and then we have the stage of appearance and examination. Okay, and this examination is actually an oral examination. Okay, so after the written submissions, the court asks both the parties to appear and examines them orally, right? And after that, after the appearance and examination, the next stage is the framing of issues. The framing of issues, right? अब यही चार्ट मैं नीचे कंटिन्यू कर रहा हूं. आई एम कंटिन्यूइंग दिस बिलो. आफ्टर द फ्रेमिंग ऑफ इश्यूज, नाउ द ट्रायल or the hearing of the suit starts. Okay, so first misconception that we have, that we will appear in the court and the suit is going to start, right? And the hearing is going to start. No, hearing or the trial happens at a very later stage. Okay, and at the end of the trial, the court is going to pronounce the judgment, is usually followed by a decree. Okay, so this is the step-by-step procedure for. हम लोगों ने क्वेश्चन पूछा था. The question was कि how does an ordinary suit run? So how does an ordinary suit run? This is the step-by-step procedure for an ordinary suit. But even after passing of the decree, the suit is yet not over. Why? Anyone? After the decree has been passed, the suit is yet not over. Why? Execution. Okay, Jaya, very good. The winning party would like to go for execution. Jaya, that part is true. But what about the losing party? What about the losing party? Appeal. Very good. So after the judgment and decree, there are two courses of actions possible. One party is going to have the decree executed and the other party is going to appeal. Or he can also go for review, or in some cases even revision. ठीक है? तो देखो, this is just a basic timeline by which an ordinary suit runs, right? Now the question is, why do we need to make this timeline? देखो, if we see, plaint is in order 7, summons is in order 5, and written statement is under order 8, right? So यहाँ पर देखो, the thing that I am trying to stress is, देखो, if we see the sequence of CPC, what CPC has done, it has served the summons even before the filing of the plaint, because order 5 comes before order 7. Summons पहले serve हो गए हैं, and the plaint is being filed later on. It is just not the case. You know कि until and unless the plaintiff has filed the address of the defendant, where are you going to serve the summons, right? First thing. And second thing, under order 5 rule 2, if you have the bare act, go to order 5 rule 2, and you can see that every summons is accompanied by a copy of the plaint, right? So whenever you serve the summons upon the defendant, it has to be accompanied by a copy of the plaint. That means the plaint has been already filed. So from this we can see that CPC is not arranged in a way like an ordinary suit runs, right? That is why this timeline, we have to make this timeline. This falls upon us. Appearance and examination, this is order 9 and 10. Then the framing of issues is under order 14. And then we have the trial or the hearing under order 18. The judgment and decree, this is under order 20. And then the execution is under order 21. Then the appeal, the first appeal is under order 41. Review is under order 47. And then we have revision, which is section 115. Now, go. Once we have made this timeline, then what we are going to do, तो section order का correspondence देखा था हम लोगों ने, that section order correspondence we are going to fit it right over here, right? तो यहाँ पर we have summons as order 5, but actually अगर हम लोग देखें summons के लिए we have summons as section 27 to 32 order 5, and the filing of the plaint starts the suit के लिए we need section 26 and order 4. ऐसे ही जजमेंट एंड डिक्री के लिए सेक्शन 33 रेड विद ऑर्डर 20, execution 36 to 74 and read with order 21, right? So the section order correspondence is a good thing, but it must not be random, must be upon this timeline. So plaint, this has to be read with section 26 and order 4. Summons has to be read with section 27 to 32, read with order 5. Execution, this is sections 36 to 74, read with order 21. Judgment and decree, this is section 33, read with order 20. Appeal, this is sections 96 to 99, read with order 41. Review, this is section 114, read with order 47. Okay. So, online students, the point that I am trying to make here is CPC is a very important subject, and it should not be studied section wise and order wise. Okay, it's a very important subject, and that is why there is one particular method of studying CPC, which is to arrange the whole of CPC upon this question, like how does an ordinary suit run, and then to go to the timeline, आपने timeline बना लो, and timeline पे हम लोग वो section order का correspondence जो है वो fit कर देते हैं, ठीक है? So this is the proper method of studying CPC, ठीक है? All right, students, everyone, did you get the point? ये वाली बात, is this clear? Right? Okay. Right. Chalo. Now, so in PLA, what we do, or this is my subject, so what I do is, first of all, I discuss the entire timeline. Okay? The timeline is key. This is how we are going to cover the entire CPC. Okay? And now, if you go through the plaint, before you file the plaint, right, you have to keep in mind, you cannot file the plaint anywhere you want. Okay? You cannot go to any court. Suppose the suit is to be filed in Guwahati, I cannot go to Mumbai and file the suit, right? The suit must be filed in Mumbai, in Guwahati itself. So you cannot file the plaint in any court. It must be a court which has jurisdiction. Before we start studying this timeline, what we need to understand is the court must have jurisdiction. The plaint must be filed in a court which has jurisdiction. Okay. Now, a court has jurisdiction. What does it mean? Anyone? Yoshita, Jaya, Aditi, Chandramohan, Parakram, Janani, anyone? And I'm not taking everybody's names, just not possible. Abhilasha, Tala, anyone? Kokila, Harika. What do you mean by the court which has jurisdiction? Anyone? Court which has jurisdiction. How do you explain this? How do you explain this? Anyone? Parakram, if you are saying something but it's not audible, you have to type it. There is some problem with the sound system here. If you are saying something, it's not audible to me. Although I can see that the mic is oscillating, the court must be competent to try the suit. Very good, Parakram. Yes, the court must be competent to try the suit. Okay? Right. Although what Parakram has said is correct, but it's a bit vague, right? And Parakram, just listen to me. The court has legal authority to hear and decide. Okay, Aditi. So the power of the court to try the suit, or the legal authority to try the suit, that's a jurisdiction. Okay. So jurisdiction का मतलब क्या होता है? It means power or authority of the court to try a suit. Right? But याद रखना, dear sir, Chandramohan sir, I did not know that you are a faculty. My apologies to you, sir. I did not know. I thought you were a student too. My apologies, sir. Right? Okay, so the power or authority of the court to try a suit. Right? But yaad rakhna that jurisdiction is not a single concept. It has many faces. Right? So we divide the faces into three parts. The word jurisdiction is divided into three parts. The first and the foremost is subject matter jurisdiction. The first and the foremost is the subject matter jurisdiction. The second one is the pecuniary jurisdiction. Right? And the third one is territorial jurisdiction, or the local limits of jurisdiction, right? Okay. So the term jurisdiction is divided into three parts: the subject matter jurisdiction, the pecuniary jurisdiction, and the territorial jurisdiction. Okay. Now, the provisions for these, for subject matter jurisdiction, there is no specific section, right? But the inference is taken from section 9. The inference is taken from section 9, which is, because you are studying CPC, which is suits of civil nature. Wahan par, if you have gone through the Bare Act, it says that the court shall have jurisdiction to try all suits of a civil nature unless their cognizance is expressly or impliedly barred. Okay? So there the term uses suits of civil nature. So the subject matter jurisdiction, what kind of cases are going to be taken by the court? It is all suits of a civil nature unless expressly or impliedly barred. Okay? That gives the court the subject matter jurisdiction. Okay? What kind of cases can be taken by the court? Now, secondly, we have the pecuniary jurisdiction. Now, for this, the provisions are under sections 3, 6, and 15. Section 3 is going to give you the hierarchy of the courts, like the court of small causes, and the civil courts, and the district court, and then the high courts, right? And then we have section 6.6, which is pecuniary jurisdiction, also known as valuation, right? We have to understand कि valuation कैसे करते हैं suit की. And lastly, we have section 15, which says कि the suit must be filed in the lowest grade competent to try it. Okay? So all of that is under the heading of pecuniary jurisdiction. And the last one and the most important one is the territorial jurisdiction. This is from section 16 to 20, right? So where do you file the suit? In the territorial jurisdiction of which court? That is going to be under section 16 to 20. and that depends upon, right, like suppose there is a right which you contest upon an immovable property. So the suit must be filed wherever the property is situated. That is under section 16. I just give you one example. But then we have, what if the wrong has been committed not to the immovable property but to a person, like defamation has happened or assault or battery happens. Wahan par, where do we file the suit? Wahan par the answer is in section 19. And if you go through the illustrations of section 19, you will find both these examples there, the defamation one and the battery one, both one. Okay. So that part is the territorial jurisdiction. Okay. So we are discussing this here because you cannot just go to any court and file your plaint. You cannot just file your plaint in any court you want. Although the timeline will be this, but it must be a court which has jurisdiction. Before going to the timeline, what you should do for a proper understanding of CPC, must go through these provisions, right? Section 9 is going to give you the subject matter jurisdiction, and then the pecuniary jurisdiction is going to be under section 3, 6 and 15, and then the territorial jurisdiction is going to be under section 16 to 20, right? First thing. Second thing, yahan par dekho, this, yahan par after the suit has been filed in a court, it is not necessary that the suit continues in that court. There are also provisions for transfer, okay? The defendant, the suit is filed by the plaintiff, and plaintiff is known as the dominus litis, right? If you have gone through sections 11 to 15 or 25 tak agar pad liya hai, must know that plaintiff is the dominus litis. He gets to choose the forum ki main suit kahan file karu. But it's not like the defendant is left with no options. The defendant has two options. One, he can have the suit transferred. Okay, the provisions are from sections 22 25, and the other thing he can do, he can raise an objection in the court wherever the plaintiff has filed the suit. Now those provisions of raising objections and the transfer of suit, they are from sections 21 to 25. Okay, now where does the court, in which court does the application lie, or what powers does the court have? Section 24 may, if you have gone through, the district court and the high court, they have the powers to, right, the district court and the high court, they have the powers under section 24 transfer a suit to another court, or they can also withdraw the suit and try themselves. That is all under sections 21 to 25. Okay, if suppose the suit is being tried in, let's say, in Maharashtra, and you have to transfer the suit into Jharkhand, the transfer application will be filed in the Supreme Court. Okay, because jahan par ki different high court ki subordinate hai, then the transfer application is always filed in the Supreme Court. So all of these provisions must be studied under the heading jurisdiction. All of these are there, right? Now, ab dekho, even after you have studied jurisdiction, you cannot go directly to the timeline. Dekho, why am I explaining this? Because first of all, to start the timeline that we had made, right? ये जो timeline हम लोगों ने बनाई थी यहाँ पर, cannot just go to any court. It must be a court which has jurisdiction, and that is why we discussed all this. Okay, but even if you are filing the plaint, you must also keep in mind the principles which must be there in a plaint, right? And उसके लिए आपको देखना पड़ेगा parties, right? Who can be a party to a suit, right? And secondly, what is the framing of the suit, right? Frame of suit जिसे हम लोग कहते हैं. So what can I claim? Can I split my suit कि एक suit अभी file कर लूँ and one suit I am going to file later on? Can I do this or not? That is under the parties. This is going to be under order 1, and then the framing of suit is going to be under order 2. Okay. देखो, यहाँ पर let me summarize whatever I have covered so far. Whenever you study CPC, first thing you should study is the jurisdiction of the courts, right? Because you cannot just go to any court and just file the plaint there. It must be a court which has jurisdiction, and याद रखना कि all three must be there. A few weeks ago, Parakram said the court must be competent. याद रखना, the word competent and the word jurisdiction, although they are used interchangeably, but they have quite different meanings. If you strictly see it, the word competent and the word jurisdiction, they will have different meanings. especially if you go through section 18. Have you studied section 18, everyone? Have you studied section 18 of CPC? I question. Apart from the faculty, okay. In section 18, if you go through subsection 1 proviso, it says competent. It does not use the word jurisdiction. It says the court is competent, right? The term competent and the word jurisdiction, they are used interchangeably, but there is a big difference. Dekho, if we use the term jurisdiction, that means the court has all three. That means the court has the subject matter jurisdiction, and the court has pecuniary jurisdiction, and the court has territorial jurisdiction. Okay? But when you use the term competent, the word competent can mean different things. Okay? Usually it means the court has subject matter and the pecuniary jurisdiction. It does not have the territorial jurisdiction. ऐसा हो सकता है. So if the word used is competent court, the competent court, it will have subject matter jurisdiction and pecuniary jurisdiction, but it will not have territorial jurisdiction, right? Even if you go to section 24, section 24 में भी देखोगे subsection 1 का clause A, वहाँ पर है the court subordinate and competent to try it. If you have the barracks, anyone, if you have the barracks, if you go through section 24, subsection 1 clause A, the court subordinate and competent to try it. That court has the subject matter and the pecuniary jurisdiction, but that court does not have the territorial jurisdiction. ठीक है? तो आगे से if you come across the term competent and jurisdiction, याद रखना they are not the same thing. In some context, the competency can also be interpreted as the court has subject matter and territorial jurisdiction, but the court does not have any jurisdiction. Okay? Yeah, this is also possible in very limited context, yes. The point that I am trying to make here is the terms that we use, competent and jurisdiction. A court which has jurisdiction or a court which is competent, right? They can mean different things depending upon the context. Okay? So I wanted to tell Parakram. Parakram, is this point clear? Competent की meaning क्या होती है and jurisdiction की meaning क्या होती है? This point clear? Chalo. If you have any questions, you can put up any questions. Right. But one thing which I recommend to everyone, before you study CPC, first you can, this is the jurisdiction part, and then you go to the parties and the framing of suit, and then you go to the timeline. This is the proper way of studying CPC. Okay? Don't just study CPC section wise and order wise, because that does not give you a proper understanding of the topic. Even if you understand the topic, the problem that CPC has is not arranged in a logical way, and that is why we have to make this timeline. Okay? First thing. Second thing, even if you understand the topic, must know the proper use of that topic. Okay? So provision, where do we use it? As I take it, if you are going through CPC, you must have studied res judicata. Have you studied res judicata, everyone? Students, you have studied res judicata? Okay. Right, so my question is, can you point out in this timeline, where do you find res judicata? Because I have not mentioned it, and that is why I am putting up the question. Where do you find res judicata in this timeline? And it's okay, beta, give a wrong answer. Appeals. Okay, Jeremy? Anyone else like to try? Anyone else? Where do you find res judicata? What is the use of res judicata? Okay, देखो. Jeremy, sorry, it's not appeals. Okay, देखो. First thing you should understand that res judicata says once the suit has been heard and finally decided, right? That means once this timeline has been completed, the suit has been heard and finally decided, right? What res judicata does, it bars a second suit, right? If the first suit की जो timeline होगी, इसमें we cannot find res judicata. But the second suit will also start in a similar way. The plaintiff is going to come to the court and file his plaint. That's how the second suit is also going to start. The summons will also be served. But then, in the second suit, when the defendant comes and files his WS, that is where the defendant is going to raise the point of res judicata, and he is going to say that this suit has already been heard and finally decided. Right? Yaad rakhna that plaintiff is never going to say that my suit is barred by res judicata. Why will he say that? If his suit is barred by res judicata, he will not be able to file the suit himself. That is why the defendant in the WS of the second suit, he raises the point of res judicata. Okay? So, did you get the point that I was trying to make? That even if you understand res judicata, what it is, you must know the proper use of it. Jeremy, did you get the point? कि second suit होगा, उसके WS में वो raise किया जाता है. Is raised in the WS of the second suit. Res judicata, the suit is not maintainable because this suit has already been heard and finally decided. Get it? I can explain how does it happen. Am I audible? Okay. Okay, so in the limited time that I have tried to cover as much as possible. Do you have any questions? Parakram, Jarni, Nupur, do you have any questions? Badao? Yes, Parakram, go ahead. If you have any question. So this is, okay, Jarni. This is my way of teaching CPC. Okay? Because practically, if you go to a court, if you have ever been to a court and you have done the internship, or if you are in practice, this is the timeline that you are going to find. Always. Okay? Okay, why is the CPC not arranged in a logical manner? Well, first of all, they did try it. Aisa nahi ki they did not try it. They did try it, but then due to practical difficulties, sections can only be amended by the legislature. It can be the state legislature or it can be the union legislature. But the orders, they can also be amended by the High Court. They had to separate. Orders are those things which the court encounters from day-to-day readings. And there the court can come into a situation where the court does not know कि मैं यहाँ पर क्या करूँ. The court can become clueless in some situations. That is why the courts have been given orders in a detailed manner, and the high courts have been given the power to amend the orders. Sections have to be separated from the orders, and that is why there could not be a logical sequence by which they could be arranged. So this might be slightly off topic, but why does India have not more cases? Parakram, the answer to your second question is that most people as a society, we do not try to obtain compensation. That's a mindset that we have. Like suppose there is defamation. Defamation is a tort as well as a crime. If defamation happens, not many of us are interested in the compensation, but many of us are interested in, I will make sure that that person goes to jail. And that's because people have this mindset कि IPC में या BNS में I am going to prosecute that person. So it is actually both. So answer तुम लोगों जो तुम्हारा question है Parakram, the answer is a bit of both. The courts, they do try to encourage it. Like recently, I don't know if you know it or not, there is a tort of, this is a recent tort which I discovered and somebody told me actually, that alienation of affection. This is a tort of, Parakram, you should look this up, tort of alienation of affection. Okay, this is something which I recently found out कि okay, ऐसा भी tort होता है. Now what we did, what one of my seniors did, he said कि this is a tort. Now I said I have never heard about this tort. And when they filed the tort case in the court, even the judge was not convinced, and they had to convince the judge for a period of 6 to 8 months, right? So after that, the judge was finally convinced, okay, yes, this tort exists, and then she admitted the plea, right? So it is a bit of both. Your answer, the The answer to your question is, Parakram, it is a bit of both. The courts are not inclined to hear tort cases, and the people are also not filing them. Okay. So, if you don't have any more questions, then probably I would be ending the class now. Do you have any questions, or should I end it? More questions? Okay, I hope my lecture was helpful, because this is something that I had come up with, because you're not going to find this in any book. This is, want to take a screenshot of you if you want the recording. This is how you should study CPC. Husband wife के बीच में divorce हो रहा है. This is the timeline that is going to be followed. अगर tort में negligence case है, how is negligence going to be filed? This is the timeline that is followed. 90% laws are civil, and that is why in the 90% of the laws, this is the timeline that you are going to. So if you are going to see it practically, why not study it the way it goes? Right? Okay. If you don't have any questions, then I'll be ending the class now. Okay. Thank you everyone, and especially Chandra Mohan sir. Although I mistook you for a student, but it's very nice interacting with you, sir.
Subscribe for more content.